Marrying a U.S. citizen versus marrying a lawful permanent resident. I want to talk about adjustment of status for the purpose of this video. I want to answer this question. I want to elaborate more. I tried to answer that question before, and the most recent question was as follows. Can you please elaborate more on unlawful presence? I am in removal proceedings. However, I'm married to a lawful permanent resident. Can I adjust status? The answer is no. This is why you cannot adjust status. First of all, let's describe what is adjustment of status. All right, let's define it. Well, adjustment of status is the process in which you can apply for a green card without leaving the United States, inside of the United States. That's what we call adjustment of status. So if a person is in removal, the simple fact of being in removal, it's because something went wrong. They overstayed their visa, or they filed some type of application that got denied, or they committed some type of crimes and now they're in removal. Several reasons, right, why a person will find themselves in removal. But moral of the story, or the bottom of line, is this: the fact that the person find themselves in removal proceedings simply means that this person is not lawfully present anymore. Unlawfully present. And because the person is not lawfully present, when they marry a lawful permanent resident, lawful permanent resident, for the purpose of adjustment of status, lawful permanent resident is not an immediate relative, which simply means that they cannot waive their unlawful presence. The way it's going to play out is this: you can either, after the I-130 is approved with USCIS, try to terminate removal proceedings, file for I-601A, unlawful presence waiver, and once that one is approved, then you can go through consular processing and hope to get your visa from outside, right? Because of this unlawful presence, and because the lawful permanent resident person is not an immediate relative for the purpose of adjustment of status and for the purpose of waiving unlawful presence in terms of adjusting status in the United States. That's the reason you have to go through consular processing. Some people, what they do, they will administratively close their case so they can get a waiver to allow them to go outside and get consular processing a visa from outside. But remember, if you go outside of the United States, you're taking your own risks. There's never a guarantee to come back, but you can take precautionary measures, right? Filing a waiver and hope it gets granted, and hope you go out and come back. But what is really better to do is to actually wait for the spouse to become a U.S. citizen and try to adjust status inside of the United States. The reason why you will be able to adjust status inside of the United States when the spouse is a U.S. citizen, it's because the spouse is an immediate relative and automatically unlawful presence is waived, right? So, but if you find yourself in removal proceedings and that spouse is not yet a U.S. citizen, what's going to happen is, well, if let's say they order you remove, eventually some people just stay, and then once the person in question becomes a U.S. citizen, and the I-130 was already approved when the spouse was a lawful permanent resident, what are they going to do? They're just going to try to reopen the case, dismiss removal, terminate removal, hopefully, right? Because when the case is already closed, try to reopen it, it's quite challenging, right? You join motion with ICE, try to reopen that case, terminate removal proceedings, then adjust status. That's the difference. The only difference is the fact that Lawful permanent resident is not an immediate relative for the purpose of adjustment of status. It only works if you are adjusting status while you are lawfully present. For a good example will be you still have your F1 student visa valid, or L1 visa valid, or H1B valid, and you marry a lawful permanent resident. Then at the time of filing, if you still have that visa valid, you can adjust status. But if not, the person has to be a U.S. citizen in order for them to allow you to adjust status and automatically waive unlawful presence. I hope that's clear. I hope that's clear, right? But if you need a consultation, you want me to elaborate more, you need a consultation because you have something coming up with the court, any type of hearings, I'm here to help. Consultation link is in the description box below. Until next time, bye-bye.